This video will explore the key components of the Council of Europe's Convention on Cybercrime and how it helps Australia regulate crime in the online space. I will explore the following points with regards to this topic. Firstly, what the Convention is and what it aims to do. Secondly, the types of cybercrime the Convention targets and the procedural safeguards under the Convention. Thirdly, what Australia's obligations are as signatories to this Convention. And finally, how the Convention helps Australia regulate online crimes. So, number one, what is the Convention on Cybercrime and what does it aim to do? The Convention on Cybercrime was adopted by the Committee of Ministers of the Council of Europe in 2001 and is ceded to by Australia in 2013, along with 35 European countries and other non-European countries including the United States. It is the first international treaty to provide for investigation and global cooperation in relation to computer and internet-based crimes, that is, cybercrime. According to the preamble, the objective of the Convention is to achieve a greater unity between different countries, prioritising the pursuit of a common criminal policy aimed at the protection of society against cybercrime, which can be achieved by adopting appropriate legislation and fostering international cooperation. So, what types of computer crimes does the Convention primarily deal with? These are found in Chapter 2, Section 1 of the Convention, and are sorted into four main categories, or titles as they are referred to in the Convention. Title 1 concerns offences relating to the security of computer data and systems, such as illegally accessing, intercepting, interfering with, or misusing computer systems or computer data. These are all found in Articles 2 to 6. Title 2 concerns computer-related offences, namely computer-related forgery and fraud through the manipulation of computer data or systems. These crimes are detailed in Articles 7 and 8. Title 3 concerns computer-related offences, namely offences relating to the production, offering, distributing, procuring, or possessing of child pornography through computer systems. This is found solely in Article 9. Finally, Title 4 concerns offences related to copyright infringement and related rights. This is found solely in Article 10. In addition to making certain online activities a criminal offence, the Convention also sets out procedural provisions relevant to how signatories must conduct specific criminal investigations or proceedings in relation to these crimes. The provisions primarily concern the search of, interception, seizure, and preservation of collected data, and puts in place conditions and safeguards to ensure there is a balance between the aims of the Convention of creating a common criminal policy and human rights and liberties, such as the right to privacy. So, what are Australia's obligations under the Convention? As signatories to the Convention, Australia has agreed to the articles held therein and must implement its requirements, firstly at the domestic level and secondly at the international level. So, in relation to the first point, what measures are Australia required to take at the national domestic level? Quite simply, they are required to criminalise and define the four categories of offences and the procedural provisions we just discussed in Australia's domestic law. Turning to the second obligation, Australia is also required to establish, as stated in the preamble, a rapid and well-functioning system of fast and reliable arrangements for international cooperation in order to facilitate the detection, investigation and prosecution of criminal computer offences at the international level. For example, Chapter 3 of the Convention sets out arrangements for such cooperation between countries in relation to the collection of electronic evidence for criminal offences and extradition and mutual assistance procedures between signatory countries. So, how has the Convention helped Australia? Although Australia only acceded to the Convention in 2013, Commonwealth legislation was heavily influenced by the Convention after its adoption. After accession, the Cybercrime Legislation Amendment Act 2012 also came into force, which further translated the articles of the Convention into Australia's domestic law, especially with regards to the storing of communications data and procedural law. These laws significantly aid Australia in combating the sophisticated criminal offences we have discussed, enhancing the ability of law enforcement agencies to rapidly obtain important data, not only in Australia, but from agencies sharing information around the world. Notably, as required by Article 35 of the Convention, the Australian Federal Police and State and Territory Police Forces have joined to put in place a 24/7 contact point for overseas enforcement agencies to ensure continuous cooperation. A key example of this is the well-known events of Operation Rescue, which was begun solely by the Australian Federal Police but spread through international cooperation until numerous countries were assisting, investigating and sharing information. This led to the arrest of almost 200 suspected pedophiles and the rescue of 230 children. I hope you have enjoyed this video and now have an understanding of the Convention on Cybercrime and how important it has been in aiding Australia to legislate against and combat computer crimes. Thank you.